Thank you for that introduction. It's very good to be with you all today. Um, initially, this was an invitation to President Barack Obama, so I am a very weak substitute. Let's concede off the top. But I nonetheless glad to be here, and what a stunning view as well. And so thanks for the Institute for the invitation. Um, what I thought I'd focus on tonight in my remarks, departing a little bit from this important conversation on a nation-to-nation relationship, but I will touch upon that, but is to focus on the United Nations, because I think that the the engagement that I had the opportunity to have while serving as U.S. ambassador, I think gave me a lot of insights into the workings of the United Nations system, the human rights system, what it can do and what it is unable to do. What tribes, what First Nations, what Indigenous people should look to the UN to do, and what is maybe a bridge too far for the UN to do, and where we should look for other institutions, particularly domestic institutions, to do. I think from the outside, the UN can be very opaque because it's what you see is a bit of kabuki theater. It's very rehearsed. By the time it's public, everything that is meaningful has been negotiated among states. So the first point is that the Human Rights Council, the UN generally, is a member state organization, meaning it's a group of countries that have come together, and it's about countries. It's for countries, and uh, certainly a lot of countries like the United States and Canada do want to have involvement by civil society, Indigenous peoples. But at the end of the day, decisions are made by states, and that's always important to bear in mind. Let me get a little bit more granular on the specifics on the Human Rights Council as an example of the overall multilateral system. The Human Rights Council is composed of 47 member states, voted by the General Assembly to 3-year terms. Canada has served previously on the Human Rights Council. The United States is currently a member. You can do 2 3-year terms, and then you have to be off. And so it's 47 members, and they're elected based on regions. And so Canada, the United States, is what's called the WEOG, Western European and other governments. There's the GRULACs, which are the Latin American countries, and there's the African group. And each grouping is assigned a certain amount of seats that they get voted on at the General Assembly. All resolutions are adopted by majority vote, but most are adopted actually by consensus. And Indigenous peoples resolutions, at least in the Human Rights Council, have always been, since inception of the Human Rights Council in 2006, adopted by consensus. It is important to keep that in mind because part of the challenge is you want to maintain that consensus. And so that's where the negotiations occur, because every state then who's a member of the council has a voice. And there's some states that are, and look, there may be challenges regarding with Canada. There may be challenges with the United States. Mexico, Indians in Mexico have challenges with Mexico, but these states tend to be the leaders on these issues. The ones that are difficult are countries like China and Russia and Indonesia, who don't want any voice by Indigenous peoples in the United Nations, or very limited voice. It's also important to recognize that the body, Human Rights Council, or the UN generally, is a political body. It's not a juridical body. It's not there to litigate cases. It doesn't hear cases and make decisions. It makes decisions based on the politics before it. And that is an important fact to keep in mind because it tells you something about both the powers of the Council, the powers of the United Nations, and what you should expect from the Council. So let me just reiterate that first point, that it's most critical to bear in mind that when we talk about the UN, that it is about states, it's run by states, it's voted on by states. And so the decisions are going to be either the consensus decisions or the majority decisions of states. And states have interests of certainly representing all the people within their body, but that means that they're representing the interests of all Canadians, and that means the right, the left, the center, and it's also determined based on, of course, the present government. And of course, we've seen an evolution on Indigenous issues for the on the Canadian positions. The present administration being far more forward-leaning on important matters like violence against women than the prior administration was within the United States setting. The second point I would make is this, and I don't mean this to be depressing, because I think a lot of people look at the United Nations as potentially another vehicle to have issues brought before and resolved. But it's important to understand what issues can be resolved there and what issues that we shouldn't look for that institution to resolve. The second important point is that the United Nations and the Human Rights Council specifically has an incredibly broad docket. It's dealing with every human rights issues under the sun, and frankly, Indigenous peoples issues are not the most contentious. In fact, they're one of the least contentious. Uh, Issues like country-specific resolutions. So there's Syria is on the docket of the council. Let me tell you, the debates on how the council addresses Syria is something in which is high stakes, and every country cares about it because it's an ongoing war where people are tortured and killed on a daily basis. It's obviously going to be a conversation that brings a lot of things, a lot of people's, a lot of states' interests to bear. South Sudan or Burundi, all of these crises around the world get brought to the council. In addition, there's contentious issues like LGBTI rights. Let me tell you, when you have a conversation about, as contentious as conversations may be in countries like Canada and the United States about those issues, when you're talking about the UN body, when you have entities, when you have states like those who are members of the OIC, the Organization of Islamic Cooperation, or some African states, this kind of conversation becomes much, much more challenging. Things like fundamental freedoms, like what are the limits of freedom of expression, and what can we do online as opposed to offline, internet freedom. So these are just big, big issues, and with all of this, and with the limited bandwidth that the UN has and the Human Rights Council has, these things regarding Indigenous peoples do not get a lot of attention. That doesn't mean that we shouldn't engage, and I will get to how we engage. The third point I would make is that the powers of the Human Rights Council and most UN bodies are frankly extraordinarily limited. What can the Council do? They're important powers because they can shine a spotlight on a country that has particularly dire human rights situations. And that actually has extraordinary power, because when you elevate those stories, when you tell those stories, then you're able to take the first step into resolving those issues oftentimes. But the powers are just that, of reporting. They're of evaluating. They're of assessing. It's not like the United Nations Security Council, which has coercive authority. But of course, that's in peace and security matters, and it requires the votes of a majority of members of the Security Council and all permanent 5 members of the Security Council. Oftentimes, a bridge too far on many issues. I lay this out, again, not to dissuade engagement with the international multilateral system. I lay this out because I want to make an important point, that oftentimes those things in which we are going to have advances, whether in the United States or Canada, are going to be through domestic processes. They're hard-fought processes. They're political processes. They are litigation processes. I mean, there's been land claims here in Canada that have been highly successful, certainly been true in the United States. We litigated a case from 1996 to 2010 regarding mismanagement of trust funds in the United States. And ultimately, it led to a settlement of $3.4 billion. It's called the Cobell litigation, that was distributed among individual Indians all across the United States. But this, as somebody who spent his life prior to this short stint as a diplomat, as a litigator, I will take any day of the week a strong domestic system rather than the international system. And the reason I would do that is because of one word: enforcement. When you go into court, you can get an order. When you get an order, you can get it enforced. You can throw somebody in jail if they don't abide by that order. You can seize assets. It determines property. It is hard law, and that is the value of domestic institutions, domestic dispute resolving institutions like judicial bodies, and we have to focus on the value of those, and sometimes that's going to take reform because oftentimes tribes, for one reason or another, have been locked out of those litigation processes. Um, and over an extended period of time, through a string of litigation in the United States, we have had greater and greater success of achieving a lot of what I think our communities have strived for. You talk about the nation-to-nation relationship in this conference. The nation-to-nation relationship in the United States was not preordained. It was not just going to happen. It happened with a lot of activism. It happened with a lot of hard work. It happened with a lot of litigation. Just not very far from here, in the late 1960s and early 1970s, Indians were being arrested for fishing in their usual and accustomed places. They had a treaty right that said that they could fish in their usual and accustomed places. Nonetheless, they were getting thrown in jail time and time again. And then that led to people like Billy Frank Jr. and Hank Adams coming up with a strategy, a litigation strategy that led to, of course, the seminal case of U.S. v. Washington, which said that in the Pacific Northwest, 50% of the take of all fish in the Pacific Northwest went to the tribes. And that led to a incredible economic boon for the tribes. And that initially, well before gaming, everybody thinks of gaming, but for Pacific Northwest tribes, it happened well before then. It happened with fishing because that was the economy at the time. And so this kind of action, where it led to litigation and strategic thinking, that is what has enhanced the nation-to-nation relationship in the United States. We still have a long way to go. I mean, we still have our daily struggles in our courts that we litigate all the time, and we still support leadership that will support our issues. We've been blessed over the last 8 years with President Obama, who has been the most forward-leaning of all presidents as far as tribal issues. Prior to President Obama, for a long time, since studies came out from the U.S. Department of Justice, starting in about 1991, that Native women, and I know that this issue is not going to surprise you because you have similar issues here, but Native women were more likely to be victims of violent crime than any other racial gender category. I don't know. I mean, if you look at our news in the United States, people talk about black on black crime. They talk about inner city crime. Native women more likely to be victims of violent crime than any other racial gender category. And that study has been repeated time and time again. Now, this is the other part of that. All other groups, the principal perpetrator is of the group. Black on black, Latino on Latino, Asian on Asian, white on white. For Native women, for natives generally, the vast majority of the perpetrators were non-Indian. So why was this? That is because of a case in the mid-70s called the Oliphant decision by the Supreme Court, which said that tribal courts could prosecute Indians, but not non-Indians when they committed crimes on the reservation. And what the Oliphant decision did is it meant that there was general impunity for individuals, and sometimes in areas, some of these rural areas in the United States, highly hostile to Indians. So the good old boy comes onto the reservation, beats up an Indian woman. The only person that could prosecute him is the state prosecutor or the U.S. attorney that might be 200 miles away. So these crimes just went without any prosecution. And with impunity, what we know is that it incentivizes more bad behavior. And that's precisely what happens. That's what the statistics bore out. In 2013, due to a significant amount of advocacy from tribal representatives, President Obama signed a law that for the first time, the VAWA reauthorization, Violence Against Women Act reauthorization, provided criminal jurisdiction over certain crimes of violence against women crimes on the reservation for tribes, irrespective of whether the perpetrator was Indian or non-Indian. I think that's the first time ever in the world where an indigenous court actually has authority to prosecute somebody outside their community. Now, look, there's more work to be done on that, but that is an example, I think, a textbook example of what we talk about when you talk about the nation and nation relationship. Because what that recognizes is it recognizes that this is a polity. This is a nation that is in the best position to resolve its own problems, but it has to have the jurisdictional power to do so. It has to have the resources to do so, and it has to have the wherewithal to do so. And that is why it's a nation-to-nation relationship, because the obligation of the United States ought not be to try to impose a solution. The obligation of the United States in a true nation-to-nation relationship is to work with the tribes so that they can resolve the issue for themselves. And this is, I think, a very elegant example of what can happen. So let me bring that back to the Human Rights Council and to the UN multilateral system. One of the reasons why, despite all these limitations of the UN human rights system, that tribes and First Nations and their representatives should continue to engage is that it is not a waste of time and resources. You can actually highlight issues. It is a political body, but that politics has strength. Canada does not want to look like it is not in accord with its international obligations. The United States does not want to look to the international community that it's not in accord with its international obligations. Well, the United States didn't want to do that until January 20th this year. Now it really doesn't care, apparently. But generally speaking, the United States doesn't like to look like it's departing from its international obligations. And when a body like the Human Rights Council establishes and through resolutions the specific dictates as to what are the expectations of states that we have all agreed to, then that has great value as a political instrument domestically. And that's also true for many other domestic issues, whether those are land issues or resource issues. You talked about the consent requirement of the Declaration on the Rights of Indigenous Peoples. That consent requirement is very strong. Think about the notion of if that is lived up to. That every time there is a development that implicates a tribe, a First Nation, or tribal members, or First Nation members, that they have to provide their consent. Well, that changes everything if it's fully enforced. So this kind of conversation that is ongoing at the UN is worth engaging in. There is an absence, though, presently. There's not a lot of either First Nation representatives or tribes in the United States actually participating in these bodies. There's all kinds of reasons for that, historical reasons for that. One is that the UN has typically only recognized non-governmental organizations and not representatives tribes. There's an ongoing conversation right now in the UN in New York to change that. And there had been some progress made in the Obama administration to support those changes. And Canada was in recent times supportive as well. So these international bodies can also, now that we've had the Declaration on the Rights of Indigenous Peoples accepted universally, it was adopted 10 years ago, but only in 2010 did the United States and a few other countries support the Declaration. Now it's essentially universally accepted. And as something that's universally accepted, it is a set of principles that every state is supposed to try to strive for. Now, I've heard criticisms that say, look, binding, this is not a binding instrument. It's not what we call a convention. It's not a treaty. But we have to remember, everything in the international community is not enforceable like domestic hard law is enforceable. So the difference between something that is a treaty and something that is a declaration is not as significant as I think people give weight to it. Think about this. What is the most important, what is largely considered the most important international instrument on human rights? The Universal Declaration on Human Rights. That it's today still considered. You can pull any human rights treatise off the shelf, and it would be wanting if it does not include the Universal Declaration, because it's considered such a core document. But it's not a treaty. It's none of it's binding. In the international affairs, the difference between binding and non-binding is not nearly as big as in domestic, because in domestic everything is enforceable in courts, or should be. And what this does is you can use these UN bodies as political instruments. We've had, you may have heard, an issue over the last year or so on the Standing Rock Sioux Reservation regarding a pipeline called the Dakota Access Pipeline. And while I was serving as ambassador, the chairman, Dave Archambault, visited Geneva, and we welcomed him to provide remarks at the Human Rights Council. And what that did was that elevated the issue even further, and it internationalized the conversation of Standing Rock. And that is an important political instrument. Now, I think based on the recent election, it didn't produce the exact results as one would have hoped. Nevertheless, it allows for us to change the conversation. The other thing that these international bodies can do is there's a substantial amount of resources that are provided to entities like the Human Rights Council. And what you can do is utilize those resources in order to further the principles of the Declaration. One of the things that did during my tenure, working very closely with Canada and others, is to put a lot more attention on what is a worldwide scourge on violence against Indigenous women and girls. Look, I talk about the U.S. situation. You have a situation here, but if you actually look at the statistics, violence against Indigenous women and girls occurs virtually everywhere there are Indigenous communities. There's all kinds of reasons for it. Part of it is a lack of prosecution. Part of it is that they're in very rural areas. Part of it is they're in communities that are not empowered to address these issues. There's all kinds of reasons for it. But what the UN can do is it can identify these issues. It can study them intently. It can come up with reports that identify best practices. It can come up with reports that are saying what states are not doing and what they should do further. This is one of the reasons why we spent a lot of time at the UN over the last few years on trying to change the various mechanisms to allow them to better enforce issues regarding Indigenous peoples. One such mechanism is called the Expert Mechanism on the Rights of Indigenous Peoples, commonly referred to as MRIP in UN speak. This body was relatively powerless. It could only study those things in which, by resolution, the Human Rights Council said, study this issue. But there was a World Conference on Indigenous Peoples a few years ago, and based on that World Conference, there was an outcome document. And one of the key outcomes was to change the MRIP so that it would be a much more powerful instrument to ensure that states were allied with the Declaration. The Declaration of the Rights of Indigenous Peoples has basically everything you would want in a declaration. It's a very strong instrument. The principles enunciated in there put tribes and First Nations at the center as the decision maker on virtually everything that impacts their communities. And so to the extent that we can get implementation worldwide of those principles, I think a lot of what you're talking about today is going to come to fruition. How do you do that, though? You do that by utilizing these international mechanisms. You do these through a domestic strategy that's going to be most important, but it can be aided by these international bodies, and these international bodies will allow you to study these issues. They will allow you to. The emirate now has the authority to identify when a state is having a particular issue and provide guidance as to how it can address those issues in compliance with the Declaration of the Rights of Indigenous Peoples. So these are very important instruments that allow us to address these issues over time. That's the other thing I would say. Look, everything at the UN, like everything I think you'll see in our work that we do, whether in the U.S. or here, takes far longer than we'd like. I mean, we'd like to snap our fingers and make it happen, but these things take a long time, and they take step by step. They take litigation and cases. They take political movements. In the U.S., look, prior to 1934, we didn't have a nation-to-nation relationship. That only happened starting in 1934 with the Indian Reorganization Act that allowed tribes to be separate governments. And then they were very limited governments. And it was only through struggles for the next 50 years that finally tribal sovereignty was really recognized and treaties started to be enforced. And so these things take activism, they take litigation, they take purposeful affirmative steps. And what we can do through these international bodies is enhance that approach, enhance the movements that we make domestically by taking those resources and making sure that there's a it can be used as a political weapon in achieving some of these aims. One of the critical things the um, the 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 my final point will be that the Declaration also is vital because what it does is it sets what are the expectations from states. And that is critically important. What is the measuring stick that states will be judged by? And if states fall below that, then you have a political instrument. It also concretizes these norms. And what I mean by that, it sort of constitutionalizes the norms. What we've seen in Native history is that we go through periods where uh, uh, where governments, whether in the U.S. or Canada, are either more pro-tribal or less pro-tribal, and some are more respective of enhancing self-governance, and some are less respectful of that. That vacillation means that you're hurt in some instances. What the Declaration does is it establishes a standard that means that there is a political cost to dropping below the expected standard, and that too is very critical. I know we're going to try to do some questions, so I'm going to close with this. Um, I was just talking a little bit earlier that there is a discernible difference between the histories and the realities of Native people here and in the United States. And neither is better than the other or worse than the other. They're just different. I remember when I was down in Durban, South Africa, with her then national chief, Matthew Kumkum, and he said during a speech that the policies of of Canada regarding education of Indian children were genocidal. That was the term he used, I think, genocidal or something of that nature. And it was interesting because of the reaction. The reaction of the Canadian government was unbelievably strong. From if and I use that because by comparison, if the president of the National Congress of the American Indians, basically the head body in the United States for tribes, had said something like that, it may be on page A20 of the Washington Post. I mean, it would get no attention in the U.S. And that's because we have largely, until the most recent administration, we have struggled with invisibility. That's been one of the most biggest challenges. You don't have that challenge the way we have that challenge, and that invisibility hurts significantly because oftentimes laws or policies of general applicability are adopted, but they have implications for tribes and tribal members that are different than the rest of society and can hurt them in more dramatic ways. And so that invisibility means that our concerns are sometimes not considered. And so that is a strength here. I think one of the strengths that we've had in the United States is a recognition of our governing bodies. Most tribes in the United States have tribal court systems, and many have police forces and fire departments, and they have government instrumentalities. And so I think part of what this conversation should be about as well that you're having is how does that engagement between tribes in the U.S. and First Nations here help us learn how to get some of the better parts of what each has and address some of the challenges that each face. So with that, I'm going to end. Again, thank you so much for the invitation, and I guess I'll take some questions. Thank you.
Who has questions? Charlie. Mr. Ambassador, thank you so much for your comments, and I suspect you don't want a question on number 45, or as he's referred to by...
I can talk about it now, so...
as a genitalia grabber in chief, but I digress. You mentioned the Human Rights Council. Help me understand, as a Canadian, how Saudi Arabia gets there. You can do that very briefly, but more importantly, do you see a time when Indigenous peoples, whether it be in North America, Central America, or South America, have a real voice on that council? If we're serious about nation to nation, I would think, for at least from a Canadian perspective, we would have some mechanism to ensure their voice is at that table as opposed through the state government. And as you well know, Canada under the current regime is a huge supporter of the UN, and we are lobbying for a seat at the Security Council. The absence of the US and Australia, and I guess Canada, but thanks to the enlightened leadership of Jody Wilson-Raybould, we will bring UNDRIP into fruition. But without rambling on here, Saudi Arabia, why, and why not Indigenous groups in those three jurisdictions on that council with a direct voice?
So on Saudi Arabia, again, I think we get this question all the time. If the Human Rights Council was a council of states with good human rights records, Saudi Arabia should not be on it. Neither should China. Neither should Russia, frankly, nor Cuba, nor Venezuela. There's a number of others. Burundi is on the Human Rights Council. But the fact is that it's, again, a political body that's voted by the General Assembly. And Saudi Arabia, if it wants a seat, is probably going to get a seat because Saudi Arabia is very powerful in the international community. They throw a lot of money around in a lot of places. And that kind of resource gives them a lot of weight. And so these are not based on the kind of criteria that we would like, but they are based on a political process. And that's why they're members. The U.S. has supported oftentimes in particularly grave situations when Muammar Gaddafi's government was on the council, having them removed. We advocated and were successful in getting Sudan to drop out of a council race, and in a number of other instances. But if I had to guess, I would say it would be very difficult to eliminate in totality all the problematic human rights governments from the council. The fact of the matter is, as a permanent 5 member of the Security Council, China is going to get a seat in all likelihood if they want a seat. And their human rights record is not going to improve anytime soon, despite our best efforts to try to make it so. Indigenous peoples. There is a process right now occurring in New York that I urge First Nations to get involved in, that is seeking to separate and provide a different status for Indigenous peoples to have different participatory rights at the UN that are different and more enhanced than NGOs. That conversation is ongoing. The U.S. was the most forward-leaning country in having enhanced rights up to January 20th. I can't speak for the U.S. government anymore, so I don't know what their positions are anymore on this issue. I suspect that they're probably not going to be as supportive as the Obama administration was. But Canada is also in that debate. And Indigenous peoples do participate at the UN, and they do participate in the Human Rights Council. But what they need to have is a different type of participatory rights. If what you're asking is whether or not they can vote on resolutions, I think that's always going to be a bridge too far at the UN, because states will not provide any entity other than states that right. It just, I think, as a political matter in the international community, I think that's a bridge too far. And when I say that, I'm not saying that I think it should be a bridge too far. I'm just saying, as a political reality, it's a bridge too far. It is a close one.
Hello. I was at Standing Rock this summer with my two boys. Sorry, I'll stand up.
Oh.
And I was there when the Mandan and the Adats and the Harakuru came and opened up that teepee that hasn't been open for over 100 years. And during that process, we sat around the table that night and we had a feast. And there was an interesting conversation about this whole notion of free and prior and informed consent. And the notion of it. And then that whole obligation or the responsibility of the duty to consult. In the United States, it's unique relative to what we're faced with here in Canada. And what was really interesting for me was David's stance was that how can you have free and prior and informed consent when a proponent crashes through your backyard, government supports it, and releases any responsibility on duty to consult? How can we fix that notion? I mean, we go through it here with mining companies in BC, we go through that with mining companies in Canada. And I think that whole notion of free and prior and informed FPIC is a real dangerous notion that goes against Indigenous people. There needs to be, when you talk about bridges, is there a way that we can change that deliberation so that Indigenous people have a clear understanding of what that notion really means?
But look, I think you're pointing to a very important point, and the fact is that the Declaration's plain words are free, prior, informed consent. Free, without coercion; prior, before any action is taken; and informed, meaning you know all the information you need to know to make a knowledgeable decision. That's the intent of the words, right? The fact of the matter, though, is that each state gets to interpret those words right now. And different states interpret them in different ways. In fact, I think my personal view is that the U.S. interpretation of that is at odds with the plain language. I can say that now. I couldn't say that 2 months ago. But in my judgment, it's at odds with the plain language. But this is why this is where these UN bodies can actually be helpful, because you can get an entity like the expert mechanism or the special rapporteur or the permanent forum to actually have an assessment of state conduct and whether it is in compliance with those terms or whether it's not. I think that if you actually realized the plain meaning of those words, then that would be a extraordinary empowerment of First Nations or tribal communities, because it would mean that they get to determine, they get to decide when and how things happen that implicate themselves. So I think that's a big part of what communities want, and certainly would have been a different case in Standing Rock if that was provided. And I think, frankly, the Dakota Access Pipeline would not be built had the election gone differently. As you know, President Obama asked for an environmental impact study that would have taken 2 years and would probably meant that that project couldn't have gone forward financially. So I would also say this: I think DAPL is also an example of how you can utilize political tools to get the objectives that you want. One of the things that you will see with respect to DAPL is that uh, a lot of tribes who have a lot of resources pulled their banking from Wells Fargo, and that had a huge impact on Wells Fargo's decision making. And so you have to say this: what is your objective? What are the tools at your disposal, political, legal, etc., and whether internationally or domestic? How do you utilize all those tools to maximize the probability of success on your objectives? That's what each community has to do on each of these things in the near term for a specific project. And longer term, they have to utilize international bodies to ensure that the standard is set so that the expectations are set in a way that is fair and is going to lead to the better results.
Sego, from a Cherokee to Mohawk, I know you know about the Iroquois Confederacy. Having a constitution that is copied by the United States, we've always been strong on this nation to nation relationship. And to talk about it, there's a woman from Canada, and I really want to talk about not downplaying the effect of the United Nations from our perspective. A woman named Lovelace, I believe, in the 1980s went before the UN on discrimination charges. And they found in her favor that she was, and back in Canada, it brought about a big change. And that big change resulted in Indigenous women. A lot of things happen as a result of that. So from where we sit, there's things you can do at the UN if you plan it right and you have the right cause. In 1956, Castro invited Iroquois Confederacy members to come to Cuba. And they went on their own passports, and he gave recognition. And again, it brought about the similar effect of what does a nation mean to other countries? I'll go back to 1923. When Canada went before the United Nations and asked if they could be considered league member, there was another person that was there, and his name was Discahe. And Discahe was representing the Iroquois Confederacy. Both Canada and the Iroquois Confederacy were competing for recognition from the United Nations. And Canada had to lean to Great Britain to say, help us. So the Great Britain became silent because all they had to do was to say we're allies with the Iroquois Confederacy. So to me, going outside of the country to look for support for causes, it all depends on how you frame and how you structure it and what cause that you're fighting for. So I agree with everything that you said, except to say I don't want to downplay it. Everywhere I go, what's the reverse of downplaying it? You know, like we all rest with nation recognition. We tell Canada that every day. Because in this country, they have been calling us bands, small, irrelevant, etc. And from the smallest to the largest, we've always maintained that we are part of nations in Canada. And this nation to nation is something that we're reminding now, non-natives and natives, why we should be comfortable with that. So I want to commend you for that, and it's not a question, it's more as if something to pass on to you. from our perspective, I guess in Canada, our view. We've had situations that has occurred that we've got a little bit of recognition, enough for that battery to be recharged and continue on our quest for nation recognition. And our battle here in Canada is the same. So I found your talk to be very interesting, and I'd like to see if you would comment a little bit on that, because I see American courts making decisions, and it's outside of U.S. and outside of Canada, that have been helpful in some cases. So it's not just a UN body, but external. And what we're all looking at is how can we mobilize and organize with a nation mentality that would get us the desired results that we're looking for.
And look, I think that's a very good point, and I share the sentiment. I mean, I wouldn't spend 3 years in Geneva if I didn't think it was meaningful. I think it's meaningful for Indigenous peoples. I think it's meaningful for all kinds of other issues. And I think that these UN bodies and the inter-American bodies, regional bodies, are all particularly helpful. But I think the point that you made is the same point that I'm making, which is this: you have to identify how it's going to help you in specific terms. You have to have a plan, and you have to understand what are your domestic remedies, what are your domestic tools, what are your international tools. Then you have to assess all of those and figure out how you can best spend your resources in order to achieve those objectives. And it may well be that highlighting an issue internationally is going to be among the best ways to do it. But what I see sometimes is if there are expectations that are unrealistic, then what that leads to is that inevitable disappointment, and not only disappointment but disillusionment, and people then rejecting these bodies as useless. I don't think they're useless. I think they're vital, but I think they're vital in terms of how you utilize them effectively, which is, I think, what you're saying. We just have to make sure that we understand what they're good for and what they're probably not going to be helpful with respect to. And I think as we make those judgments, we will have better results from these bodies, and we will have better results for our communities.
Okay, last question before second last. I have one too.
Thank you, Mr. Ambassador. I want to follow up on my friend Chief Mitchell's question. You gushed earlier about the use of domestic remedies in pursuing your goals. With utmost respect, that doesn't really work in Canada.
Okay.
I come from the people who litigated the Ahousaht First Nation versus Liz case, and we got a win in the court where the court recognized our Aboriginal right to fish and sell the fish. Canada has chosen to ignore the decision. Canada has a policy of reading Aboriginal wins in court as narrowly as possible and minimizing their effect. So with utmost respect, the domestic remedies don't always work for us. What I'd like to hear from you is advice for First Nations in Canada who do want to use the tool of the United Nations and the commissions under the United Nations, and how would you advise us to get our issues before them? You said we must get them before them. I agree with you, we must. Now, what advice do you give for us to get those before them? Thank you.
Thank you. Look, I litigated on behalf of Indian tribes for 20 years, and there were cases I didn't bring because I didn't think they were going to be successful, even though the underlying rationale would have been an outcome would have been just if the tribal side won, but the law wasn't there, or we get a problem of lack of enforcement, and sometimes that takes more than just litigation. Sometimes the domestic takes things like what happened in Standing Rock, and certainly there have been fishing wars in places like Wisconsin. So I'm not simply saying the courts, but I am a litigator, so I do tend to kind of put the scale and the thumb on courts. As far as the international system is concerned, I think that there's a few ways to do it. One is there is a special rapporteur that receives and is allowed to receive and act upon, is supposed to act upon communications from anybody out there. So she receives communications. It's a Philippine indigenous person right now. It was James Anaya before that. And they then act upon those communities. So that's one tool. The other is participating in various forums. There's the expert mechanism. It meets for a week in July in Geneva. Lots of issues get presented there. Now you can also invite the expert mechanism to engage with the state to better their practices. There's in addition the permanent forum in New York that is a forum intended to address these issues. I think the key aspect of this is engagement. That what I see, unfortunately, at the UN too often is that tribal issues, First Nations issues, are represented by NGOs, and some without direct links to constituencies, specific constituencies. And so they sometimes advocate things that I'm not sure are the most pressing concerns of the communities they are supposed to represent. And so I've always been a big advocate of additional engagement from those who are coming from communities themselves, elected officials, appointed officials, those who are answerable to a constituency because they will identify those issues that are most important to them. So, look, I think that there is a lot of ways to utilize these UN bodies. It depends on the specific issue. It depends on the objectives. It depends on how you're utilizing domestic mechanisms in alliance with whatever you're doing internationally. So it sort of depends on many factors. But I think the point I was trying to make a little bit earlier is that what it takes is to think strategically about and soberly about what these entities and bodies can do and how they can then enhance your ability to achieve the goals of your communities. And they can do so, but we have to know what they can do and what they can't do.
I guess that food coming in is kind of like turning up the music and drumming you off your speech. But anyway, you're from the Cherokee Nation in Oklahoma. Yeah. For this year, there's a group of Canadian businesses going down to the 28th Annual Sovereignty Summit of the Supreme Court of Oklahoma. Has that been a significant? I mean, this isn't a tribal summit. This is by the Supreme Court of Oklahoma. Is that a significant event?
No, I will be there as well. I'll be speaking on a panel at the Sovereignty Symposium, and I think it's a very good conference. I think it tends to address issues that are very granular. Things like how do you do economic development? What are the restrictions? What are the legal implications? And so I think it does offer a lot of insights into some of the things. And the tribes in Oklahoma, after the last 20 years, including my own, have been incredibly successful in a whole wide range. And everybody thinks about gaming, but we have manufacturing plants and tourism and all kinds of other things. So I think it's an important conference.
So anybody who wants to go, get a hold of the National Consortium for Indigenous Economic Development. Thank you very much,
so
sir.
much.
It's been a great, informative evening. Thanks for coming to the call.
They're going to start serving dinner, but I'd like to actually ask Andre Menard to come up and do a quick prayer song for us. She's graciously agreed to do one for us.
As Mr. Harper said, I am a weak replacement for an elder, so I hope that we will take this as a blessing of our food. And it's a grandmother's song, come through, and it's called All My Relations, Kakyo Nuwakumaganak, learning the Cree. So it's a nice feminine song for political talk. Sometimes that's good. Hey yo, Yahweh, hey ya, hey yo, Yahweh, hey ya. Hey yo, Yahweh, hey ya, hey yo, Yahweh, hey ya. Kaki uni wakumagana, weheo, weheo. Kaki uni wakumagana, weleheo, yo weleheo. Heo, heya, yo weleheo. Hey yo, Yahweh, hey ya, hey yo, Yahweh, hey ya. Hey yo, Yahweh, hey ya, hey yo, Yahweh, hey ya. Kaki uni wakumagana, weheo, weheo. Kaki uni wakumagana, weleheo, yo weleheo. Hey yo, hey ya, yo weleheo. Hey yo, hey ya, yo weleheo. Hey yo, Yahweh, hey ya, hey yo, Yahweh, hey ya. Hey yo, Yahweh, hey ya, hey yo, Yahweh, hey ya. Kaki uni wakumagana, weheo, weheo. Kaki uni wakumagana, weleheo, weleheo. Hey, hey, ya, weleheo. Hey, hey, ya, weleheo. Hey yo, Yahweh, hey ya, hey yo, Yahweh, hey ya. Hey yo, Yahweh, hey ya, hey yo, Yahweh, hey ya. Kaki uni wakumagana, weheo, weheo. Kaki uni wakumagana, weleheo, yo weleheo. Hey yo, hey ya, yo weleheo. Hey yo,